Good evening. Good evening. I'm John Miko, the Executive Director of the Union League Legacy Foundation. It's my great privilege and honor to welcome you tonight to tonight's Jack Templeton Liberty Series. The Legacy Foundation is the nonprofit charity of the Union League of Philadelphia. We use the history, the values, the great collection of the Union League of Philadelphia to create, we hope, more informed, more engaged citizen leaders. We do this through a variety of programs, including programs like tonight. I do want to tell you about some of our other upcoming lectures that we have, including two in the next few weeks that I think are very timely and interesting. One, a public affairs program next Tuesday, and it's a post-election analysis with David Castagenti and Bruce Melman, who are two of the leading knowledgeable experts coming up from DC for this program. And then on December 28th, November 28th, we have a wonderful program by James Oakes, a Civil War Roundtable on the crooked path to abolition, Abraham Lincoln and the anti-slavery Constitution. So a few housekeeping items. I'm sorry, let me mention one other item. Our exhibit, which some of you I know saw for the first time tonight. We have a brand new exhibit, A City Divided, Civil War Philadelphia and the Union League. And it's about the history of the founding of this great Union League of Philadelphia and divided city of Philadelphia. So I hope you'll come down and see this great exhibit down on the ground floor in the Heritage Center. A few housekeeping items. If you'll take a moment to please silence your cell phones. We will have a question and answer portion to our program. You should have cards at your seats. Please fill them out. Staff will come around during the course of the program, and we'll get to as many of those questions as we possibly can. And now to introduce our program is the chair of the Education Committee for the Union League Legacy Foundation, Mr. Steve Targett. Steve.
Thank you, John. Before I begin, I'd like to recognize the current chair of the Legacy Foundation, Jim Dunnigan, who is with us this evening. And I think it's appropriate to also recognize Joan Carter, our media past chair. Thank you, Joan. So this evening, it's my pleasure to introduce our program, the Supreme Court Cases, Challenges, and Politics of the 2022-2023 term. We're excited to have with us this evening two leading legal and constitutional scholars, Professor Michael Gerhardt and Judge Janice Rogers Brown. Professor Gerhardt is a Samuel Ashe Distinguished Professor of Constitutional Law at the University of North Carolina and is a scholar in residence at the National Constitution Center. He's the author of 7 books, including Lincoln's Mentors, which he presented at one of our Civil War roundtables in 2021. He's testified over 20 times for Congress and was the only joint witness in the Clinton impeachment proceedings in the House. Michael served as a special counsel to the presiding officer, Senator Patrick Leahy, at the second impeachment of Donald Trump. Judge Rogers Brown served as a U.S. Circuit Judge of the United States Court of Appeals for the District of Colombia Circuit from 2005 to 2017, and before that, Associate Justice of the California Supreme Court from 1996 to 2005. She's also a lecturer at the University of Berkeley School of Law and is on the Board of Regents of Pepperdine University and the University of the Pacific, and on the Board of Advisors of the New Civil Liberties Alliance, which is a conservative libertarian law firm opposed to the administrative state. Moderating our discussion this evening is John Yoo, a Philadelphia native. John attended Episcopal Academy before he continued his undergraduate education at Harvard and law school at Yale. John is a visiting fellow at the Hoover Institution, Emanuel S. Heller Professor of Law at the University of California, Berkeley School of Law, and a visiting scholar at the American Enterprise Institute. John was also a featured speaker at a public affairs program this past May. Please join me in welcoming John Yoo, Janice Rogers Brown, and Michael Gerhardt.
You'll go in the room? Yes, I will.
Well, I want to thank Steve for that kind introduction and for inviting us back. And for those of you who were not here at my own public affairs forum, you may not know that Steve was my sixth grade soccer team colleague. And all I remember seeing of Steve was his backside because he was so far ahead of everybody else in the field. There's a great winger. And the other thing I promised, you might have seen Ed was the moderator. I promised not to make fun of his Bulgarian footwear tonight. So those of you who were there may realize I was trying to figure out whether Ed was a spy. And so I said he would wear the footwear of his opponents, the Bulgarian secret police. So I promised not to mention that anymore, Ed. So it's great to be with you. And we're going to talk about half the time about the term that just ended, maybe the most consequential term of the Supreme Court in the last 50 years. And then spend the other half of the time before taking your questions and answers, talking about what's coming down the road with the current term, which, if it weren't for last term, might itself be one of the most important term in the last 20 or 30 years because of what the courts got before. So before we talk about the exact cases from last term, I wanted to invite first Judge Brown and then Professor Gerhardt for their broader observations about last year. We saw, I think, increasingly high profile of the Supreme Court in our national politics. You may remember, for example, in the Democratic presidential primary in 2020, all the candidates were asked whether they wanted to increase the size of the Supreme Court. You might remember only Joe Biden refused to agree to that, but it gave you a sign of how important the court has become in our politics. And then, of course, the court reversed Roe versus Wade and sent the issue of abortion back to the states. We saw the leaking for the first time in history of a Supreme Court opinion. We saw the Supreme Court expand the definition of the right to bear arms, to be able to carry guns outside the home. We saw expansion of the right of religious minorities. So we have a very consequential term. Before we talk about those individual cases, though, I just wanted to invite you, any sort of broad themes about the court, its direction, its style of interpreting the Constitution. Judge Brown, why don't you begin? And welcome to Philadelphia.
Thank you. Well, I suppose we ought at least to start with a little conversation about originalism, because I think back in 2010, when Elena Kagan was going through the nomination process, she made the comment that we are all originalists now. That might have been of some comfort to people who were invested in originalism. This version of it starts in about 1985 with Ed Meese speaking to the American Bar Association and saying to them that if we're going to have a constitution, one of the things that we need to think about is how we interpret that constitution, and it ought to start with the words and the meaning. And so that started a process that maybe some people would say came to fruition in this particular term. But the interesting thing about that is, although the reason for focusing on original meaning was both to curb the court, which was guilty, I guess, of judicial supremacy, and also to curb what was called living constitutionalism, this idea that you could use the general phrases of the Constitution and kind of insert whatever your personal predilections might be. But one of the things that happened on the way was that even though originalism, you could maybe say, has prevailed, there are now as many versions of originalism as there were of living constitutionalism. So it hasn't worked out quite the way people anticipated.
Professor Gerhardt.
Well, thank you. Thank you, John. I just want to briefly thank you and of course the opportunity to be here. It's always a great pleasure. and a privilege to have a chance to visit with folks. I want to say that up front in case I get carried out later. I'm going to start not with originalism, but with a couple of other themes that I think are also part of the last term of the Supreme Court, and I will end with originalism because I think it's connected to these others, but I do think a couple of other themes are worth pointing out. The first is that, of course, the Supreme Court has changed. The composition has changed over time, and that's not insignificant. President Trump did something no candidate for president had ever done before, and that is he gave a list of the people from whom he was going to select his justices. And he gave that list to the public during an election. He didn't do it just once, he did it a second time. Of course, he basically was doing it the second time, using the same list again. But that was itself historic. And it really was an interesting moment in constitutional history, because the American people had never known during an election who was going to likely become a candidate for the court before a vacancy really had arisen. However, of course, there was a vacancy at the time President Trump ran the first time, and that was after the death of Justice Scalia, whom I might add was my constitutional law professor.
You show no scars.
I show no scars. My class remembers that he called on me for 2 days straight. So that really got me ready for oral argument. It's like I survived. But I want to focus. I really want to stress the fact that because of the change of the court, that deliberate change of the court's decision-making changed. And that, of course, is a classic way to change constitutional law. And I think we would not have had the overruling of Roe but for the change in the Supreme Court. After all, look at the people sitting on the current court. None of them were there when Roe was decided. I think only Justice Thomas was there when Casey was decided. So this is a very different court. Now, a second thing also is important, and that is in choosing justices. President Trump, for example, emphasized they were going to be in the mold of Justice Scalia. But Justice Scalia didn't always abide by originalism. I appreciate Judge Brown's comment that there are many different forms of originalism. And that itself raises a problem. And that is, what are exactly the justices looking at when they make a decision about constitutional law? Originalism is rarely cited by the court as a basis for decision-making. The thing that's cited the most is precedent, which, by the way, is exactly what the new appointees were appointed to change. And that's happening. It happened with Roosevelt, happened with Lincoln. It happened with William Howard Taft, who made, I think, an extraordinary number of maybe 6 appointments in a single term, which is amazing if you think about it. Those were all transformative appointments. And I think it's fair to say even the 3 appointments made by President Trump are transformative. They've given us the court, a different kind of court than we've seen before. And I think even its version of originalism is different than what we've seen before. So lastly, I'll just say that all these different things, in a sense, are all moving in the same direction. The transformation of the court, precedent, and of course, originalism itself. And those are things to watch for the future.
Judge Brown, do you have any comment? I think Professor Gerhardt sets it up nicely, and we're going to see these in the opinions we're about to discuss, this conflict between precedent. And for those who are not lawyers, I hope most of you are not lawyers. But for those of you, who are not, when Mike says precedent, he means respect for previous decisions. Right. When Judge Brown mentions originalism, it's the idea that the Constitution should be interpreted based on the understanding held by those who drafted and ratified the constitutional text. So mostly people in Philadelphia, right? That's where the Constitution was drafted and much ratified. So do you have any thoughts in response to Professor Gerhardt before we talk about the cases from last term?
Well, just one caution, you said that originalism looks to the meaning of those who, to the, I guess, the intent of those who drafted it. But everybody has kind of given up on that idea, and it goes now to the original meaning, something that they feel more capable of capturing. The other thing I think, and I should have made a note, but you had said maybe it's not even the originalism that people thought would be the result of this transformation of the court. You know, I think the answer to that is yes and no. In one sense, I think it very much hewed the line of this idea of neutral principles and not going beyond that. On the other hand, at this moment of triumph, a lot of conservatives feel like that doesn't go nearly far enough, because just the words with neutral principles can't carry the freight that they want it to carry.
Very good. So why don't we talk a little bit about something uncontroversial like Roe versus Wade and abortion, although it's not quite as controversial as the World Series outcome. So you know, actually at the end, we're going to ask you both, how did the Astros cheat again in this World Series? Yes, we all know they cheated. It's, you know, you're watching judges. How did they bribe the umpires this time? So
I heard one of the umpires was an original.
So in brief, again, for those who are not lawyers, in Dobbs versus Jackson Women's Health over the summer, the Supreme Court 6-3, but really 5-4. On the point of overruling Roe, it was 5-4. Overturned Roe versus Wade, which was just about to be 50 years next year, and sent the question back to the states. It started out with originalism, said the 14th Amendment is originally understood, did not create a right to an abortion, but then relied on history and practice and tradition in the years after, until 1973. And much of the decision, I think this goes to Professor Gerhardt's point, wrestled with why should Roe versus Wade not receive the respect of precedent that the court usually affords many other important decisions? There are many decisions that the Supreme Court might decide differently as an original matter, but still upholds because precedent has been around for a long time, or people give it a lot of respect, or would unduly change the law. So you really have this clash that our two panelists are talking about in Dobbs. Also, you might want to talk about is this a question really can be handled at the state level? We're starting to see that in the elections tomorrow. So Professor Gerhardt, why don't you start this time? What are your thoughts about Dobbs and what happened at the court?
Well, my first thought about Dobbs, just to be repetitive, is that it was completely predictable, that I don't think it was a surprise. And part of the reason for that is because judicial selection has become more reliable in a sense. I mean, one of the things I think Republican presidents have had in common, at least since President Reagan, is they wanted to appoint justices who would overrule Roe. So given all the different appointments those presidents made, President Reagan, President George H.W. Bush, President George W. Bush, and of course, President Trump, one of the things they all had in common is they all wanted to see Roe overruled. But what happened? Not all the justices they appointed wanted to overrule Roe. And Casey is the point, is of course a great illustration of that, with Justice Kennedy and Justice Souter joining the majority to barely reaffirm Roe versus Wade, at least the first half of Roe versus Wade, the portion dealing with the so-called right. So it was something we expected. Most court observers would have expected. The second thing is that I think it does introduce interesting questions about precedent or a doctrine that we sometimes use in law school and in law called stare decisis. It's Latin. And we do that because it will confuse people.
Yes.
Well, these lawyers can charge $500 more per hour if they use Latin.
Although I bet we have a couple people here that speak Latin, or at least construe it. And so stare decisis basically means let it stand. And why that matters in constitutional law is because not everything can be up for grabs all the time. This really goes on what Judge Brown was saying. You wouldn't have stability, predictability, consistency are extremely important for the law to work. And if everything were up for grabs all the time, then you couldn't even advise your clients very well because you wouldn't know quite what to tell them. Do you tell them, okay, what's the settled law or what you think is the settled law? Well, it may not be so settled. Do you tell them, is your advice then grounded on original meaning? You have to go back and figure out, okay, look, we've got this Commerce Clause case coming up or this regulation issue. Maybe we need to go back there to the original meaning rather than to whatever Supreme Court has said. So there's going to be confusion if there's not predictability in even the way the court overrules itself. And that will be the final point I make, which is in Dobbs, Justice Alito sort of talked about egregious mistakes. Well, how do you figure out what an egregious mistake is? Some people would just say any mistake is egregious because it has consequences. So one of the things, therefore, to watch has to do with the following. Traditionally, there have been two different approaches to precedent or stare decisis that have been at odds that justices typically choose from. There is what we'll call the traditional way, which is looking at whether or not there's not just a mistake, but whether there's some other important reason for overruling the case. The other approach, which I think was common, for example, for Justice Barrett, was or is overruling something just because you think it's wrong. There's no reason to have constitutional law if it's mistaken. That doesn't make sense. So if we can find a mistake, we should overrule it. That was the Justice Scalia of the early years. And if you look at Justice Scalia in the early years, there were dozens of precedents he wanted to overrule. He almost couldn't stop himself. But by the end, he was different. And he often differentiated himself from Justice Thomas by saying, look, I'm not crazy quite like Justice Thomas, who's an originalist all the way. Occasionally I think there ought to be a little stability in the law. So that's the real challenge we have after Dobbs, which is, okay, what's next and what will be the standard or criteria for overruling when that next one comes?
Judge Brown, are you an originalist all the way? Do you think Dobbs was, did it properly handle originalism versus precedent? Sounds like Professor Gerhardt, you wouldn't say it clearly, but sounds to me you don't think it did, that it should have deferred more to precedent perhaps. What do you think?
Well, of course, he's right that it's necessary to have stability and some level of predictability in the law. It's impossible if it's erratic, if things are changing constantly and people don't know how to do business or how to decide how to handle things because it's constantly in a state of flux. So that would be bad. That's to be avoided. But I don't think stare decisis or this respect for precedent was ever intended to stop mistakes from being corrected. There used to be the thought that it was the job of liberals to keep making mistakes, and it should be the job of conservatives to make sure they never get corrected. But we've moved on from that. But there are standards for when you do it. I mean, you don't do it all the time. You probably don't do it just because it's wrong. I think that that tendency to just look at things that are wrong and you want to correct them is a quirk of young judges. You have a lot of energy. When you first get on the bench, you figure, well, it's just wrong. I want to get it right. And so it should be right. But I think judges, tend to mellow out as they get more experience, and you have to decide what hill you want to die on, right? So I think what they were doing here was saying, if you've got an egregious mistake, if there are not reliance interest, and what was the third one?
The reliance interest is a big one. For them.
Yeah, that was, but basically they had a standard that they were applying. Workability, like, does it work? I mean, can you apply it? So you have to say about Roe, that is, if ever there was an egregiously bad decision, Roe was it. Even the people who were very happy about the result in Roe could not defend the decision. They all admitted that it was very poorly reasoned. And there's a Gerhardt who says it's a bad decision because it's not constitutional law and it doesn't even make any attempt to try to be. And when you think about it, Roe, 20 years afterwards, Casey came along and really undid Roe because it apparently, even they were not convinced that it was properly reasoned, but they substituted at that point a new understanding of liberty, which was apparently unlimited. And that's where we got that great sweet mystery of life passage that everybody likes to quote. If you ever want to make judges laugh, you quote Casey's, at the heart of liberty is the right to determine your concept of existence, the meaning of the universe, and the mystery of human life. Which is really pretty broad conception of liberty. So I think that what the court did in Dobbs was right. I think they justified why they did not feel that they should be forever bound by that precedent. And, we all know that the court makes mistakes. If we couldn't overrule precedent, we would still have Dred Scott. We would still have Plessy. We would still have a lot of ugly things, Korematsu. I mean, things that the court had to come to a conclusion that was wrong, and they needed to overrule that and move on. So that's what happened in Dobbs, appropriately, I think.
Let's talk about the other, well, there are several, but the second blockbuster case from last term, also again, setting up a conflict between precedent and originalism, was the Bruen case, which involved the scope of the Second Amendment. This is actually a case where I think it's hard for originalists, because if you read the text of the Second Amendment, it doesn't clearly say there's an individual right to have a firearm. It says something along the lines of the right to have a militia, the right to bear arms. And so there's doubt about whether it protects your individual right to have a gun, or whether you're called into the state militia to serve in the military, and then you have the right at the state level to have a gun. That was litigated and decided by the court in 2006 and 2008, 2010 in a series of cases, but came up again in Bruen. And so Bruen was a question: could the government place restrictions on your right to have a gun outside your house? Court in the earlier cases had said your right essentially to defend yourself in your home gives you the right to have a firearm. So this case called on an expansion of that right. Professor Gerhardt, your thoughts?
Okay, I'm on the first batter. Which
this is where we figure out how big the strike zone is, which changed when the Astros were pitching. It was very long. When the Phillies were pitching, it became very narrow. So
it's one umpire, so it had to be the original strike zone.
that's right.
And then everybody said, "What does that mean?" Just like law. But the Bruin's an interesting case because in a way, it actually extends. It requires us to think even further about where are we going to look to decide a question of constitutional law. I mean, that's always of course, the big question in any constitutional case. But with Bruin, it turns out to be a little different than the situation was in Dobbs. So with Bruin, it wasn't really so much a question of overruling some prior decision of the Supreme Court. It had to do with what do we do about regulations, which, by the way, have been around a long time. Justice Scalia, by the way, used to say the most important form of stare decisis is what majorities have thought for a long time they had the power to regulate. Well, that 1911 law that was struck down in Bruin had been around a long time. There have been regulations of guns for a long time. And what happens if we start striking down all these regulations which have been around a very long time? Where is going to be the outer limit, or in what case might we expect the state interest to be so strong that it might allow for some kind of regulation? My first thought after reading Bruin was whether I was going to take the subway anymore, because I wouldn't want to be stuck on the subway with gun-happy people. But put that aside. I think, so one issue is going to be, one issue with Bruin has, and even Bruin itself recognized this, recognize there are going to be some sensitive places. That's a quote from the Heller decision written by Justice Scalia. And the Heller decision is really the first modern decision on the Second Amendment. One thing that's interesting about Heller is the two opinions that were sort of put forward, the majority opinion and the dissent, were both originalists. Justice Stevens in his dissent is writing an originalist opinion, just that it's not the same originalism that Justice Scalia is writing in his majority opinion. Again, extending the debate, how do we figure out what version of originalism is going to become established in such a way that we can use it to predict outcomes? The other thing about Bruin, again, just to come back to the point about sensitive places, is what are they? Are they churches? Are they schools? I think about Uvalde, which is just haunting in terms of the horror and the terror and the carnage that happened there. How do we, is there any regulatory way of dealing with that kind of trauma and horrible outcome? So that's really where I think we now have to start thinking is, okay, we can't necessarily rely on longstanding traditions because the court might find them at odds with Heller, but what might be traditional places we might have regarded as sensitive enough that we think government can either regulate guns completely or in some way in those places.
Judge, is there any way under Bruin to take account of modern challenges, the gun violence that's going on in places like Philadelphia, for example,
Yeah.
in our schools, or does originalism limit what you're able to do?
I think from the court's point of view, at least the way they approach this case, that, the answer to that would be yes, that originalism, does limit how creative, perhaps how innovative you can be. It's interesting that the question that it comes up to them from the lower court was that court actually tried to come up with a way of finessing a little bit of saying, okay, well, first, we do a two-step process. Maybe they've gotten used to the Chevron two-step, so they created the Bruin two-step.
Well, that works so well.
Yeah. But they basically said, we have to look at, what they're trying to do and then consider, in other words, tiers of scrutiny. And the Bruin court just said, no, it's, if it's, Dobbs sort of said, if it's not in the Constitution, we're not making it up. And Bruin sort of says, if it is in the Constitution, we're reading it just that way and we're not going to try to fix it. I mean, that's how I read what they did there, was to because the intermediate courts had actually tried to say, well, okay, maybe Heller says there's this right and it's a personal right, it's an individual right. But if the under the police power, the public officials are trying to control this in some way, then, maybe we can give them some flexibility. And the court just, rejected that. But they did, as with everything, it does leave open some questions. You never quite get everything answered, or it's very rare to have a situation where everything gets answered, which is one of the reasons that law takes so long to resolve. I mean, like 49 years with Roe. And you think that the Second Amendment has been around so long, and yet it's really only in 2006 that we first started grappling with this. And now even that's been a long time ago, and we still have open questions. So this question of, could there be circumstances where, the court didn't say you couldn't have a place where you could prohibit guns. It just said it can't be a whole city, right? It can't be because it's New York and it's heavily populated. You can't do that. But it didn't say you couldn't perhaps, find some specialized circumstances where it would be appropriate.
Well, I want to be sensitive to John Miko and Steve Target's promise that we'll have about 20 minutes for questions. So that gives us one question to ask about the upcoming term, but actually it continues this theme that you've both raised about this new young court that's right, young radicals, it sounds like, who think they can do anything and get the right answers and silly ideas like that, and but conflict with precedent and long time practice. And of course, that might be the very question the court has to resolve in the affirmative action cases. There are two cases, one against Harvard, one against UNC Chapel Hill. I don't know if you're involved with the litigation, Mike, if you have to, okay, good. Then you can speak openly.
Only to the extent I work there, right?
That's right. And both of these cases call on the court to re-examine past precedent because the court has upheld affirmative action, the use of race in college admissions several times, first in the famous Bakke case from the 1970s, and then it reaffirmed that precedent in the mid-2000s in a case called Grutter from Texas, and said race could be used as a factor. It can't be a predominant factor in college admissions, and you definitely can't have quotas. These two cases claim that the use of race, even in that way, violates the rights of students from races that are not favored in the college admissions system. So, Mike, why don't we start again with you? What do you think the court's going to do? You seem to think that, well, the new personnel make all the difference on the court.
Well,
so what do you think? What do you think might happen?
I think there's no question they will strike affirmative action down. And
No question.
No question. You heard it here last. My prediction, and by the way, I predicted the Phillies.
Did you really? Because I knew the Astros were going to cheat, so I predicted the Astros.
Well, sometimes your hope is the main driving force behind everything. I think because of the change in composition, affirmative action will be laid to rest. I think that will be, at least in admissions processes, so that is my prediction, and I think that because there's, John Roberts, others have signaled for some time that they're not happy with the compromise on this issue of race ever being used as the basis for a law or a government practice. In the case of Harvard, because it takes federal funds, using race even as a factor, which is what came out of Bakke in 1976. Using race even as a factor is too much. It can't. That does raise interesting questions that people mentioned, which is, it even came up in oral argument. What if somebody writes an essay about their background and their experiences, for example, facing discrimination and how they've had to deal with that? That's very interesting questions, I suppose, for the future, but it is going to be impacted in the present once the court reaches this outcome, as I predict. I do feel, if it's okay, it's the law professor in me, John, which is driving this a little bit.
I feel so bad for you, but go ahead.
Yeah. Well, you can feel my pain, I'm sure. So there's precedent for lots of things. And this does create a bit of a quandary in all sorts of areas of constitutional law. I don't think Dobbs is the first case which is leaked. I think Bowser versus Hardwick technically was the first case that was leaked. And Chief Justice Berger ordered an investigation, which I think, and I'm not sure ever found the person that leaked it. But it didn't make a precedent for the leakage the second time. In other words, not everything done before should become a precedent. And this will then also be an interesting dilemma, I think, for the court, not so much in overruling affirmative action, but again, in trying to figure out where do we stop? For me, that is going to be one of the interesting things, because as a law professor, I'm always interested in not just what's decided, but as Judge Brown was saying, what's been undecided, what hasn't been addressed, because we all know that's where the litigation will go. The litigation will focus on the sort of undecided, the gray, indeterminate areas. And the last thing I'll say is we focused a lot on originalism, but the real action in constitutional law and in law has to do, again, with precedent, because overruling is just the tip of the iceberg. Even if you're not going to overrule something, you still have to live with it and interpret it. And the question becomes, what are you going to do? Do you narrow precedents sometimes? Do you mentioned earlier, Bruin expanded a precedent. So, and that's the real activity in constitutional law. The activity being, how do you construe the precedents that do exist? Narrowly, broadly, do you gut them, and so on? That's going to be, I think, what we really have to watch for.
So Judge Brown, is this some place we could find you in agreement with Professor Gerhardt on your prediction for the Harvard UNC Chapel Hill cases?
I think I always hesitate to predict because I'm really bad at it. But
We have
as
that
Yogi Berra said, it's about the future. It's really hard.
Well, we have that in common, though. Yeah.
But I on this one, I really think that it's probably going to go, one, because the both the evidence and the statistical work that's been done here is just so devastating. It's so clear that there is discrimination here, and maybe even invidious discrimination, which is a word we've sort of dropped out of the context of this discussion. But it's a painful case to me, because I'm thinking of John Marshall Harlan's Great Dissent, right? Where he says, ours is a colorblind constitution, and it's something that's always been very poignant and very personally appealing to me.
Go ahead.
And we've moved far away from that, of course, but now it's like we've come full circle, and we now have this situation where a remedy that was needed, that perhaps really responded to a great wrong and tried to correct it, but didn't put any limits on that. What happens with that is what usually happens, which is that whatever power there is abused in some way. And so now we have something that should have been a remedy, which is now being used to do exactly the thing that we were trying to cure, which is just, that horrifies me, that's where we've ended up. So I think, and let's face it, it was already on life support. I mean, O'Connor only gave it 25 years, and I think we're at 19 or something. Mm-hmm. So there was a recognition that this was not supposed to be forever, and that it should come to an end. And so I think that creates even more pressure in the direction of saying, let's just bring it to a close.
John, can I just add one thing?
Really quick.
Okay, really quick. What we didn't mention so far is originalism. Because in the affirmative action case, as Justice Kane pointed out, it was only until more than 2 hours in the oral argument that anybody mentioned originalism. And the problem that comes up here is originalism is not going to help you much in the affirmative action cases, because the Reconstruction Congress that fashioned the 14th Amendment passed a series of race-conscious laws in the immediate around that same time, all dealing with trying to eliminate barriers and impediments to the newly freed slaves and their descendants. The Freedmen's Bureau, for example.
Interestingly enough, the Supreme Court of that era mostly eviscerated.
Exactly, which is more than ironic.
Yeah.
It's tragic. And so I just want to point out that originalism, it'll be interesting. This is an interesting test for the court itself, because it can't really ground its decision in originalism. So again, we get back to that question. Okay, what's going to be the basis for the decision?
Okay, good. So I want to thank all of you for sending in such good questions, which John has helpfully filtered. So if your question doesn't get asked, it's not my fault. But here's the first question. Is the precedent that was established by Major League Baseball in 2017 regarding cheating in the World Series limited only to the Houston Astros? Okay, I'm sorry I kept talking about this World Series thing. Good first question. We're gonna not ask either of you to answer.
I love Dusty Baker.
Okay, second question. Dusty Baker, cheater. But anyway, so if the Republicans win a majority in the Senate, which we'll know about tomorrow, will they reject all Biden nominees? If so, if there's a possibility of a Supreme Court opening, would that seat be unoccupied for the rest of President Biden's term? That's a very interesting question.
Yes.
Yes,
Yeah.
I would say no.
Okay, why?
It may not be
I
all.
keep it short because we only have
It
15
may not be
minutes.
all the lower court nominees, but I don't think it'll be a lot. And if there is a vacancy, I think it absolutely will not be acted on.
Really? Judge
Okay,
Brown, you
well,
don't think so? Why?
I would give the.
Can I just a factual point?
And that's
here.
because of precedent.
Because as I say, when Justice Scalia died, which was at the very last year of President
That's
Obama's term, he nominated Merrick Garland, who disappeared from the national scene, but he was a wonderful guy. And Merrick Garland never got a hearing and did not get confirmed, and that seat was vacant for basically more than a year.
That's true. I suppose if they make the argument that Biden is a lame duck and that therefore they need not act on these. But I hope that was an aberration and that will not continue to happen. I think everybody who is nominated should have a hearing and should get a vote, period. That's the way it should be.
Okay. Second question. A student from St. Joe's Prep asked this question. What kind of regulations would you see this court imposing on weapons?
Well, the court isn't
The
going
court,
to impose.
Or allow,
any
maybe allowing.
regulations. Maybe allow.
What kind of regulations would the court allow on firearms?
Well, schools would be a good place to consider. It's hard to imagine why weapons should be brought into a school. And whether you're talking about an elementary school or high school, I mean, again, the idea of weapons being brought in around elementary school students, middle school students is, to me anyway, kind of mind-boggling. And I grew up in Alabama. We're both from Alabama, by the way. We share that as well. I say that because I've been around weapons a lot.
Mhm.
And I would think places of worship are, at least for me, another place to consider, why bring weapons into a place, at least again, for me, is meant for peace and really sort of thoughtfulness and spirituality, all of which I think are made better if you don't have weapons. Yeah.
Well, I mean, all of that actually, sounds very good, very plausible, but I have heard the argument that the reason that we have these horrific school shootings is precisely because they are soft targets. And the people who do these horrible crimes know that. And so I think you would probably get an argument from people that, in fact, it might be better if there were perhaps officers in schools who are armed. I think it's tragic that we reach that circumstance because, as you were saying, having grown up in Alabama where everybody, had a gun and had the
I heard the
rifle.
just said.
Yeah, had the rifle, in the rack in the back. And people didn't go around shooting people. So, something else horrible is happening in our society that doesn't, I think, have to do with where people have guns. It has to do with how people feel, what they feel it's okay to do, which there was a time when that would never have been countenanced. So I don't know that we're going to even be able to come to a conclusion on that reaches a consensus because people feel very strongly and very differently on these issues.
Here's a very good question too, not from a St. Joe's prep student. So does the majority's rationale or approach to precedent in Dobbs also undermine other precedents such as Obergefell? So Obergefell is the decision where the court held that there was a constitutional right to same-sex marriage. So I guess the question is, do you think the court's going to overrule Obergefell too in the future, just as it did Roe in the Dobbs decision?
Well, I think Obergefell is certainly weakened because of Dobbs. The reasoning in Obergefell, that's the case that upholds a right to marry, a right to same-sex marriage. But the decision itself rests on a couple of precedents, one of which was Romer versus Evans, which is an equal protection case, and the other of which was Roe versus Wade. And without Roe versus Wade, of course, we still have Romer versus Evans, and that may not be threatened maybe at all. We just don't know. But all I can say is that the foundation for Obergefell is weaker, and that makes it vulnerable.
Yes, well, on that, we agree. I think that's true. And the question was at least raised in one of the separate opinions about substantive due process and whether or not substantive due process is a thing. And if so, whether the court should think about undoing that. So that would certainly weaken it.
Oh, here's a good question, I think aimed particularly at Judge Brown, because you used to be a judge. For those of you who don't know, Judge Brown was a judge on the DC Circuit, which is commonly called the second most important court in the land after the Supreme Court. See, I almost said DC Circuit. And it's similar to the Supreme Court in that all the judges are in one building in the DC in Washington, and it commonly hears the most important cases that go to the Supreme Court. And many of the justices of the Supreme Court were judges on the DC Circuit first. So you might have a very important perspective on this. Does it surprise you that there was a leak of a whole opinion from the Supreme Court? And then there's a second question. Do you think the Supreme Court really knows who leaked it and isn't telling us? And why won't they tell us? That's from a journalist, clearly.
It did surprise me. Perhaps it shouldn't. Professor Gerhardt has pointed out that it's happened before. But I was appalled, just absolutely horrified. I think it was such a betrayal. And I was thinking myself, you know, how I would feel if something like that had happened while I was on the court. And I just, it's such a violation of the norms that I just could not imagine anyone doing something like that, although obviously they did. So yes, it surprised me very much because I'm perhaps stupidly, I still have this idea that law is a special profession and that lawyers should be people of honor whose integrity is absolute. And so, yes, I was just stunned. In fact, people were calling me up saying, what do you think about this? And I said, it's a leaked draft. I can't read it. And I refused to read it until they issued the decision. Whether they know or not, if they don't, I can't imagine why they don't. And so I actually hope that they know and just aren't telling us, because if they're really that inept and cannot figure this out, it really would bother me.
Mike, do you have any thoughts about this?
I agree with Judge Brown 110%. I think that, and let me back this up by the fact that I'm not just a lawyer. I also love teaching professional responsibility. And in our profession, we are fiduciaries. That means people who must be capable of earning and maintaining trust. And one of the things about working in a place that's a courthouse, whether it's the DC Circuit or the US Supreme Court, is trust is indispensable for doing the work that has to be done there. People have to be able to trust clerks or others to maintain confidences about the work that's going on. Otherwise, it becomes impossible to do that work. You can't write an opinion, do an opinion in real time with everybody in the world watching you. That would make it impossible. And so I would say that's somebody, or whoever it is, that should not be practicing law. If it's a lawyer, we don't know. We still don't really know who did the Bowers versus Hardwick leak, which is ironic because there's a lot of suspicion about who it was. I was in Washington practicing law at the time, and so it's kind of amazing to think that one wasn't found either.
So last question, and it's actually a good question in that it asks you to think about the future. It was a question we actually had down, but we ran out of time too. Yeah. So it's a really good question. So this is a question, it's about something called the major questions doctrine. So it asks, will we see the major questions doctrine and what an influence it will have? The major questions doctrine, maybe I could put in a bigger context, because this really is a question of, is there something we didn't talk about? I mean, we talked about abortion, guns, affirmative action, really hot topics, but is there something important also going on that we didn't get to? Mm-hmm. And one of the things the Roberts Court has been up to that's, I think, really been outside the guise of the public has been really narrowing the powers of the administrative state and the executive branch agencies. But that may not be what you pick as what is it that the Roberts Court is up to that we haven't talked about that's extremely important that people should know about. It could be limiting the administrative state, but it could be something else. So maybe we could close by asking each of you, what is that issue that we haven't talked about that people should know about, that this Roberts Court is busily working away on that's going to have a big impact on our lives? So Mike.
I agree with you, John. I actually think the administrative state is very much the best candidate for that because it is enormous, and because the cases are important, and because they largely are litigated under the radar. The public generally is not aware of what's going on in those cases, even though they involve things like clean air, clean water, working conditions. And I think that it's, I begin this with a disclaimer. I was special counsel to the Senate Judiciary Committee Democrats for Supreme Court nominations from 2005 to 2020. Therefore, when I talk about this, I'm talking about it as myself. I'm not talking for anybody else. But one of the things we always knew was on the radar screen was administrative law. All the different aspects, we mentioned the Chevron doctrine earlier, all sorts of different aspects of administrative law, I think, are going to be changed. Now, how quickly I couldn't say, but I think there's going to be transformation there as well. As you preface this by saying the court even now is trying to limit the power of the administrative state, and I think that will be on their agenda for the foreseeable future.
Judge Brown.
Yeah, I agree. The administrative state is something that is being challenged in all kinds of different ways. The court, one of the things that was so surprising to me when I first came to the DC Circuit was how much deference is given to the administrative agencies. But what I see is that the court is really beginning to take we used to have something called hard look review. It's beginning to take a really hard look now at a lot of the deference doctrines. And so I think Professor Gerhardt is right. That is something that's really on their radar now. And they're beginning to look at it in terms of, is this sort of an abdication of their responsibility? And perhaps it is, and I'm glad to see them beginning to show some concern about that. The other thing that you asked about was major questions, which is a way that the court has avoided deference, right? By saying you can't just take some existing extant provision and use that and blow it up to cover things that it was never intended to cover. The West Virginia case is one in which because EPA wanted to regulate greenhouse gases, it had decided to take this very kind of obscure provision and say, well, that means we could actually tell people to change how they generate the energy for the grid, right? Like shut down coal plants and require them to do other things. So the court said that's far beyond what the Congress could have been thinking about. And unless they say that more clearly, when you're going to take over some huge part of the economy, you don't get to just invent that. So that makes sense. And one of the things that Gorsuch talks about there is he links major questions, which the dissent is saying that's kind of a new thing and we really don't do that, and we really don't. He links that to what he calls the clear statement rule, which takes it back to one of my favorite things, which is the non-delegation doctrine. So I know that's probably gets way in the weeds for most of you, but that's basically just says Congress has to do its job as Congress. It can't just outsource all of this to the agencies and let them do all the heavy lifting. And that's a really good thing because actually, one of the things that I think Congress wants is what I call plausible deniability, which is they pass something and then they say, oh, we had no idea it was going to turn out like that. So all of that needs to be reined in. And I think the court may do it. And I think that'll be a very good thing if they do.
Wonderful. So we're at the end of the hour. I hope that you will have us back at the end of the Supreme Court term this summer to find out whether their predictions were true. And I want to thank you both for coming. I think you can tell they're both lovers of the Constitution, and for me as well, it's a great honor to join you in a place that was founded to defend constitutional government in our country. So thank you very much.
Thank you. Professor Gerhardt, Judge Rogers Brown, Professor Yu, thank you so much. That was wonderful. Ladies and gentlemen, that concludes our program. Tomorrow is Election Day. Make sure you vote. And to find out what it means, come back next Tuesday for our program on the analysis of the election. And our students, if you would come up to the front, we'll love to get a picture of you with our speakers. Thank you, everyone. Have a great evening.